Hello, my lovely law enthusiast fellow humans. I'm FCA. I am an outside juror perspective who has no legal experience professionally and anything like that. I just like to do summary coverages for some cases that are being streamed that I have interest in, and the Karen Reed case is one of them that is actively going on. I'm going to be doing a recap, summary, and highlight reel speaking for days 4 and 5 of the Karen Reed trial. Day 4 was on Friday, April 25th of 2025. It was a half day. Only half of the day was streamed because the jury went on a jury view. If you didn't watch that one, I will link to those days below. And the 42, but that is where they went. That way they can get a real sense of, because we're talking a lot about from the curb to the flagpole to the door. And when they go there, they can go, okay. So that was what was happening on the second half of Friday. The first half of Friday was not very exciting. This has been one of the more days. I watched it over the weekend. The day that happened was Lally did get to do some examination of one of the witnesses that day. We had another tech expert witness laying some foundation work for additional text and things to come in. And then we had the third paramedic who was on the rig the day of the incident, who was getting interviewed. His was very straightforward stuff. He did not have the aggressiveness that the paramedic from days before had with Yannetti. It was a lot more just calm, straightforward. Yeah, this happened. They arrived at the scene. Life-saving measures were performed. Victim was taken in. And nothing really seemed too crazy with those two witnesses. They were mostly just additional information, witness at the scene, and then the tech expert was additional foundation laying. Foundation witnesses are important because you need to know how we got to this information, and it allows the legal process for certain evidence and witnesses to come in later. So it's a necessary but very dragging part of the court system. Every day is not popping off, but don't worry, we popped off on Monday. We will get there with Mr. Ian. Hold on, let me check the name. I have several things of notes going on here. Mr. Whiffen, Mr. Ian Whiffen. Now, he is another tax expert, and his specific expertise is the additional training he has from Celebrate, which is the company that is the most commonly used place to extract data from cell phones and other devices. And what Mr. Whiffen's specific expertise is in reading that, because it's one thing to have someone just pull the data and put it up on a screen and put it in a separate file or zip file, etc. It's one other thing to be able to read all of the coding and data and being able to determine that. And he was an important witness because there was a lot of controversy over the timestamp for one of Jen McCabe's text messages. That is the one that has been in question. At either 2:27 a.m. or 6:30 a.m., there was a text message that she made in the search Safari that said "house long to die in cold," and it was noted for the misspelling. And it was like, okay, well, if you're asking a search how long to die in cold at 2:30 in the morning, that's a lot more sus than 6:30 in the morning. According to Jen McCabe, Karen Reed, the defendant, specifically asked her to look up hypothermia and how long to die in cold. She's also cold. It was freezing in the morning. That morning, it was after a blizzard in Massachusetts. And, she's upset. She just found her friend, associate, in the snow too. And everyone's frantic and losing their mind. So I'm sure, just going like that, it happens. So to get to the bottom of that, because in the first trial, there was a little less detail about it. They did have some tech experts, and it's always a battle of the experts when it comes to stuff like that. And the jury gets to decide which expert is more credible, believable, and straightforward. Agreed with other previous experts that what happened on Jen McCabe's phone was that the tab was open, and she has an iPhone, and when you have a tab open, if you do not specifically close that tab for a search, if you reopen that same tab, it will maintain the original tab opening time no matter how much later you redo a search or look something else up on that particular tab. So the tab had been opened at 2:27 a.m. looking for the Ozark girls basketball team schedule was the first search that was made when that tab was open. That tab was not closed, and that tab was reopened at 6:30 in the morning, and they were able to show the other data of how they get to when this timestamp actually occurred, like when that search was put in versus when the tab was open. But when you do the first search thing, it will happen, it will just slightly overwrite whatever that first tab was, and it will highlight in red. So we saw that, and we also saw that he was just very straightforward. He didn't seem like he was rattled by anything. Cross-examination was very short with this witness because of the half day. Alessi is the one who does the tech people, and he mostly didn't spend his time attacking credibility or really going after the witness. He was doing his job as a defense attorney and really poking holes in the established timeline that had been brought up and a set in other details, because of course Brennan, for the Commonwealth, he's not going to say anything beneficial to the defense. He's going to say stuff and emphasize things that are beneficial to his side. So when Alessi got up there with Mr. Whiffen, he was like, he said, you mentioned that, because they were also talking about ambient temperature of the battery. When a cell phone battery goes inside or outside, the battery has a mode where it can track how hot or cold it gets, and that changes how the phone activates and other stuff. And it also tracks a good estimate of walking if you're going upstairs versus being in an elevator. Mr. Whiffen did bring up that one thing he had noticed with his testing was that if he was holding the phone in his hand, or it was on his or nearby, and it was out, the camera was out, is what he specifically said. If he was going uphill in a car, then the phone registered that as going up a set of stairs. It made the same step equivalency, even though he was in a car. It was all based on the phone feeling an incline, is what it is based off of. And that's why if you go use an elevator, you're not going to get that same amount of things, because there isn't an incline detected. Another thing that had come up during Mr. Whiffen's direct and a little bit into cross-examination was the facial recognition thing. This was such a surprise to me. I'm learning so much stuff. That with the facial recognition software, it doesn't notice a person specifically. It looks for general face structure. So if someone else has a similar face to another person, they can bypass the passcode and get into that with facial recognition. So if you look at John O'Keefe versus me, I could not get into the phone because I have a more oval face, a long face. My eyes are set differently, different size nose, mouth. I don't have a beard, etc. And I have bangs. But someone else who had a similar face structure to him, and this is just my speculation, this is just a suggestion and opinion, perhaps like Brian Higgins, could potentially get in there. And the reason the face software is like that, it explains why if you were to change your hair color or have your hair down versus pulled back, or if you're wearing makeup or not, that you can still get into your phone without having to look the same as when you first did the thing. No program is perfect. There was a lot of tech stuff that was very interesting. There was also a lot of talk about the camera blocking. If the camera, so like this, if the camera is blocked and the front-facing camera is blocked, it goes into a pocket mode. At least that is what he said for an iOS. We are talking about iPhones here. I'm going to presume, I do not know that just applies to cell phones. We are specifically talking about iPhones. And he brought up that when you go into pocket mode, if the camera is blocked, it presumes that it's in a pocket or something like that, and it changes how it takes in data. And that it had a warm battery temperature of being in a car. It got cold, and then it did not warm up again. So it did not have any indications of going into another warm environment after around 12:32 a.m., which is supposedly when he was dropped off at the Alberts. Well, he had to be dropped off at the Alberts because his body was there, right? And the Commonwealth is saying that Karen backed into him with a car while intoxicated, so she had to be there with a car to do it. So that's very curious. It's like, why would the phone temperature not warm up? And that really, this is speculation on my part. Speculation, please be aware, this is my opinion that we are doing here. That really opened my eyes and opened my mind up more to another possibility. I have been very stuck, and I think a lot of people have, in the idea that it's either Karen Read hit him outside or John O'Keefe was hit and rendered unconscious inside the Alberts house. But the Alberts or Brian Higgins, whoever, Chloe the dog, they could have gotten to John O'Keefe before he went into the house. It doesn't mean that they didn't do something. It's not he's either in the house or he's out of the house and Karen Read got him. He could have went up to the door and got attacked by the dog and they left him outside. He could have just gotten in the door or not stepped in the door and Brian Higgins and him got into a fight immediately, or whoever got into a fight with him immediately and he never made it inside. So I was like, oh, that's another possibility. Like, my mind was blocked to that. Okay, back to the summary facts of what happened. And yeah, he said that the camera had went into pocket mode for several hours and that the ambient temperature did not drop. Now, the interesting thing about the cell phone, about John O'Keefe's cell phone, which we heard from Carrie Roberts' testimony earlier this last week, is that John O'Keefe's cell phone was found under his body. She had picked it up. He had been laying on his cell phone underneath his torso area-ish, like waist torso area. And Carrie Roberts had picked it up and she had it in her pocket and she had handed it over to police, thrown from body, out of hand. And like I said, Alessi mostly went through saying, you didn't mention that the data here shows that he took several steps, 21 seconds worth of steps west from the car, from the curb towards the house. Yes, that did occur. You didn't point that out in the timeline. No, I was not asked to, but that is what the data showed, and I brought it up. He seemed very straightforward. He's like, I'm the tech guy. I read the tech stuff. Whatever you ask me about, I can answer it. And then that's really where that testimony ended, because the rest of the half day was reserved for the ARCCA voir dire. The jury was excused for this, but they did continue streaming the voir dire. And let me tell you, I have not been so annoyed with Brennan in a long time. Like, he was hitting Beverly Cannone annoyance levels with the way that he went at ARCCA. They didn't deserve that. He was so rude, so frustrating. Let's talk about that, shall we? How rude the audacity that Brennan had with the ARCCA witness. The first ARCCA witness we had, who he spent most of the time on because he was explained to be the main communicator with the defense team, was the ARCCA worker, Mr. Wolfe, W-O-L-F-E. And he was there, and the reason why we're having this voir dire is because this is the workaround of the violation of discovery that Judge Canone had found against the defense. She said that the defense violated Rule 14 by not turning over text messages from over a year ago that had been deleted, and hence all of the evidence was not brought in. And the defense had given summaries documents because of the deleted text messages and their explanation to the court, which just did not go well for them. The defense had explained that, yeah, we didn't expect to go to court a second time. And nobody was under any preservation orders. And when we had to go to second trial, because if you remember, they were making multiple attempts under the appellate court to dismiss the charges via double jeopardy, that did not go well. It's just hard to change court standards. I understand where they're coming from on both ends there. But the defense they said, we gave you a summary, and Brennan wasn't happy with the summary. He was like, you deleted text. You're trying to keep things from me. And the main reason that Brennan went in on this, which drives me nuts, because let us keep in mind that Brennan withheld video evidence from the Sally Port for almost a year. And that during and after the first trial, so Lally had it too. Lally's getting thrown into this with Brennan, is that they had the full access to the Sally Port file during the first trial last year around this time. And then the defense was still receiving video clips and drips into March of 2025, when they were under an order to give things over since October of 2022. So the nerve of Brennan to really push a Rule 14 violation of discovery issues, because when he was going through the uncut footage of Karen Reed's interviews, which I understand that the girl wanted to get her voice out there. It's hard to just sit there and listen to people talk around and for you, and you're like, and she wanted her side come out, but everything you say can and will be used against you. She hurt herself just a little bit, I think, with the interviews. But that's just my opinion. But for Brennan to say that the reason he wanted this violation pressed is because in the uncut footage, Karen Reed sort of suggested and maybe indicated that there was a suggestion of additional conversation with ARCCA. So kind of sort of maybe suggested there might be is why we're here for Brennan. He doesn't have any evidence. He didn't have any things. It was just he thought that there was a possible suggestion of. Okay. So then he goes into Mr. Wolf way too hard right off the bat, yelling. Like he was screaming. I had to turn my volume down. And I was at work watching this in a factory. And I had to turn my next speaker down because he was so intense. Unnecessary tone, unnecessary volume. And so accusatory. Instead of just asking, hey, I need to know what did you delete these texts? Why did you delete these texts? What were involved in the text? But he was really harping, and where I found him most annoying was several times this is a personal pet peeve of mine, it really is, when someone asks you a question and you say, I don't know, and then you ask the question again. You know what? Saying the question a second time does not suddenly make that information into your brain hole. All right? If I didn't know the first time, when you ask me the second time or the third time, guess what? I still don't know. So I was frustrated on behalf of Mr. Wolf, because like these experts, these people are trained in a way that I am not, because I could not keep my cool. I would lose my mind. I have lost my mind at bosses before for the same thing. Just, I told you I don't know. That means I don't know. The information you're seeking, I do not have to regurgitate to you. Stop asking. And it was very frustrating because, like, even when the objection was made that it was asked and answered, Like, he doesn't know. And Brennan kept in again, and his commentary got so bad that Judge Cannone reprimanded him about 4 times to watch his comments, watch his tone, unnecessary comments, and they got pulled the sidebar twice for it, and it wasn't even a very long time for this. So I was annoyed the whole time. He asked him about 4 times what specifically the defense and him talked about on specific dates in April of 2023. And the ARCCA witness was like, listen, I talked to all kinds of clients and do different projects. I was working. I don't remember the exact conversation. I know they were all short. And they were all short. They were all brief. And very beginning, Mr. Wolf pointed out that all of the conversations that he had with specifically Mr. Jackson were all brief. And then about 4 questions in, he goes, I remember they were brief. And then Brennan goes, oh, all of a sudden they're brief, huh? It was like, no, not all of a sudden. He's been saying that from the beginning. Check the court recorder, Brennan. I'm sorry, I'm really not being objective in this. I was so annoyed listening to this. But then the logistics was the answer the whole time. All of the text messages, which the Mr. Wolf estimated there to be about 100 or so text messages, and Brennan had the nerve to act like, oh, 100 text messages and they were all logistics. Yes, Brennan, let me give you all an example of a text conversation, okay? Like, hey, did you get that email we sent you with the hotel information? I did get it. I haven't had a chance to look at it yet. Okay, all of the information about your room number and check-in times are going to be there. Okay, thank you. We're going to need you at court around 10:30 a.m. Around 10:30 a.m. Okay, got it. We'll send you directions in the morning on how to get there. All right, make sure you send that to me ahead of time. I'll let you know when I get there. We'll have somebody waiting for you. Thank you. Have a good night. You too. In that little 30-second, 20-something second demonstration that I just gave, there were over 20 texts exchanged just about, did you get hotel information? Here's when you need to be there. That is all logistics information. And that's what he kept saying. And over and over and over, he said, no, we didn't discuss the case. I had my report. I was going to talk about the report. They were going to ask me questions. And the ARCCA witness did repeatedly say in 3 separate things that whatever they had, they being ARCCA, they would have given the exact same information to the Commonwealth had they reached out to them. They were like, we're not on the side of the defense. We're on the side of our work. We worked for the federal investigation, and I had to get, and it was like our conversations were mostly, hey, I got to get back to you. I got to find, because they did work for the federal investigation, and there was a federal protective order, which means there was certain things and information that ARCCA was not allowed to share or distribute to the outside world. And so he said, I have to find out what is permissible from the DOJ, which is the Department of Justice. And he goes, once I got that information, I relayed it to Mr. Jackson. And Brennan was just going on and on about, you know there's more. Tell me what you know. And he was like, I'm answering your questions. Brennan talked over him, interrupted him. Just the most rude I have ever seen Brennan against a very neutral party. And if he acts like that to the ARCCA witnesses, the jury's going to pick up on that, because when you go too hard on certain witnesses, people on the outside are going to go, what's this? You don't seem to like what they have to say. So it was annoying to say the least. And everyone in court was annoyed. Jackson was annoyed. There was a lot of objections made. Brennan seemed to just ignore everything. That was because he ignored the judge multiple times when she said, no comments, keep your comments down. Mr. Brennan, you're making unnecessary commentary. Keep your theatrics down, Mr. Brennan. And because she had to say it multiple times, it means he was ignoring her the other 3 times that she said something to him. because he is so afraid of the ARCCA witnesses. And I brought that up before, and I think that's why he went so ham on them. Then it was only a few questions in for the second ARCCA witness voir dire, because one thing that Judge Canone does is put time on a short leash. So he was mid-question, and she was like, okay, that's the end of this. Bye, everyone. We're going to have one final sidebar, and then we're going to get out of here. Then the last thing that we saw in this was the bailiff, because the court camera had went up to the ceiling fan when they don't want something shown. The court camera had come back down, and the bailiff went over and was like, get that up. So that was the last thing that we saw. That is the conclusion. I don't apologize for my annoyance towards Brennan. He's normally pretty good. I appreciate that he has been able to streamline this. He asked much clearer, definitive questions. He had a really great opening. Doesn't mean that this man is not annoying as F in other areas like today. So that is where we are. We are entering day 6, and I will see you all in the next one. Bye.